such a brief would position Trump in his response to oppose the government's position and raise any other immunity claims based on the superseding indictment, as I just did. No, that's not campaigning. You call it campaigning. We call it election protection. They say, okay, sure. Well, here's what the defense proposes since Jack won't do it because he's so lazy. All right, how about September 30th? We'll have more disclosures. October 25th this year, we have motion concerning Jack Smith's. Oh, there it is. The court should adopt Trump's schedule and reject Jack Smith's proposal, which wasn't even much of a proposal. He just said, that's your discretion, Judge. You can just do whatever you want. Jack Smith is struggling in his January 6th case in Washington, D.C. Judge Tanya Chutkan issued an order and said, listen, I want both sides. I want Donald Trump's defense and I want Jack Smith, the prosecutor's office. Remember, Jack Smith's not even a real prosecutor. He was thrown out, laughed at by us and Ed Meese and Judge Cannon out of Florida because he's not lawfully appointed. He was not appointed by the president. He was not confirmed by the Senate, but he's still allowed to play this game in Judge Chutkan's courtroom. And so she's still pretending he's a real boy, but he's not a real boy. And so they have now been ordered to assemble this joint status report. But what Jack has done here is failed to do the assignment. He's not even doing his homework. He's a bad student. The judge said, let me know how we can get this trial done quickly before the election. Propose some dates for us. Jack Smith couldn't even do it. It's pathetic. So here's what they have submitted to the judge. You can see this is going to Judge Chutkan, District Court for the District of Columbia. It's a joint status report. It's signed by all the parties here. And you'll notice we've got Molly, highlighter girl, from Jack Smith's office. And then we've got Todd Blanche, shout out, and John Lauro, shout out, for Donald Trump. It's a joint status report. And so we're going to have a little bit of a conflict here as we go through it. So let's see what they say to Judge Chutkan. They say, all right, Judge, look, you told us you issued an order scheduling a status conference and you gave us a homework assignment to file by August 30th a joint status report that proposes a schedule, right? Give us some dates for a pretrial proceeding moving forward. Now, the parties have met, and here, this is our position. So Trump and the prosecution have gotten together, and this is what we've got. Now, the parties recognize the types of motions and briefing anticipated in pretrial proceedings, but we have differing views on how you, Judge Chutkan, should schedule these matters and how these things should be conducted. So we kind of agree that these things need to happen. We agree there's a step 1 and a step 2 and a step 3, but when those should happen and how those should happen, we got some disagreements. Now, the parties believe that the speedy trial deadline continues to be tolled, meaning stopped, paused, because of at least one pending motion. And so for docket clarity, we asked the court to issue an order excluding time from the date the mandate returned through the deadline the court set for the filing of the motion. So now here's the government's position. The court has indicated that it intends to conduct its determinations related to immunity first and foremost, because that's what the Supreme Court said to do. So Chutkan wrote in her order with the court saying that there was an order denying without prejudice Trump's motion to dismiss the previous indictment, saying, well, look, I'll consider your motion, Trump, once immunity has been resolved. Okay, so immunity is like number one. That's where we're focused. Now, the government agrees with this approach, says Jack. Both the Supreme Court directed such a process on remand when they sent back this case. They told you to do this. And because the Supreme Court has stressed the importance of resolving immunity questions at the earliest possible stage in litigation. And so again, we are in the federal DC January 6th case, but look how good this quote is for Trump's New York case. The importance of resolving immunity questions at the earliest possible stage in litigation. That's not what Judge Merchan did. Judge Merchan said, we'll figure it out after the trial's over. We'll come back to that when it's a big deal. And then we'll figure it out later if it's important. Wrong. He goofed. But leads me to believe that the sentencing is not going to happen in that case, but we'll get there. Now, to that end, the government proposes below a procedure by which Judge Chutkan can schedule briefing and consider our positions about the superseding indictment that the government plans to use at trial to implicate immunity. Now, to the extent the court considers Trump's other planned motions, the government proposes that the briefing schedule for those running parallel with the schedule for the immunity briefing. Now, below, the government provides more details. So what I want to do is pause right now. Now, we're going to go through this immunity determination, and we're going to see that Jack Smith is going to leave a lot of this up to the judge. So here they say, before we jump into another trial thread, the court's decisions on how to manage its docket are firmly within its discretion, writes Jack Smith's team. So this is a punt. She said, give me a schedule, give me a calendar, give me some dates. He's not going to do it. He's going to say, it's your decision, Judge. You'll notice that the rest of this doesn't have a schedule. See this? You know who does have a schedule? Trump right here, defendant's position right here. It says proposed schedule, September 30th, October 25th, 5th, November 8th, November 15th. Then we can go maybe to spring, additional proceedings if necessary. We go all the way to 2025. There's Trump's schedule. Hey, Jack, where's your schedule, dude? You're missing it. You just said it's firmly within the court's discretion. That's it. You're going to leave it to Judge Chutkan? Pathetic. Now, to allow the court to undertake the fact-bound analysis that the Supreme Court prescribed, remember that the judges in the Supreme Court, when they talked about immunity, they said there's basically three buckets. There's absolutely immune stuff that are the roles and responsibilities of the president. If the president is articulated in the Constitution to have that power, then you can't take it away from him. You can't prosecute him because the president can't be prosecuted for stuff that was officially his responsibility. Now, the government proposes that it file an opening brief in which it will explain why the immunity that the Supreme Court dictated does not apply to the categories of allegations in the superseding indictment. So Jack's first indictment was bad. It was filled with immune conduct, as we talked about. So then he tried to delete that, right? He's like, oh, I'm going to redo that again. Second draft. He deleted what he thought was the immune conduct or additional unpled categories of evidence. So there's other stuff, like we have other evidence that we haven't put in this document that the government might introduce at trial. And so that raises eyebrows right there. What other categories? Additional unpled categories of evidence. What else? What else is in there that we don't know about? Nothing. Now, the government's proposed brief would provide the defendant and the court with detailed information about the content, form, and the context of Trump's conduct, distinguish his private electioneering activity, right? So running for office is not presidential conduct, from official action, and rebut the presumption of immunity as to any conduct that the court may deem official. Such a brief would position Trump in his response to oppose the government's position and raise any other immunity claims based on the superseding indictment, as I just did. No, that's not campaigning. You call it campaigning. We call it election protection. After the government's reply, the court can assess the parties' arguments on the record and conduct any further proceedings it deems necessary to resolve these immunity issues. Now, Trump also, they say, intends to file a motion to dismiss the superseding indictment on the basis that the grand jury that returned it was exposed to immunized conduct. So the new indictment needs to go too, because consideration of that motion would require the court in the first instance to make the very determinations described above. So they're saying, remember, Jack Smith said that he presented this evidence to a new grand jury. And so they're saying, well, you also showed them, like if you read the grand jury presentation, if you read the transcripts from the grand jury, they showed the grand jury immune stuff. He should have never done that, because consideration of that motion would require the court in the first instance to make the very determinations described above. The government believes that the court should consider Trump's grand jury claim only after conducting the fact and context specific analysis of whether the superseding indictment contains immunized conduct. So look at what the grand jury created or approved, see if it's in there, and if it's in there, then we'll deal with that problem. But don't look at what we presented to the grand jury to say maybe we showed them immunized conduct, but we just didn't include it in the indictment, which is really where the problem is, right? You can't even present the immunized conduct. So Jack Smith is kind of like, well, let's go backwards only if it looks like it's a problem now. Trump is saying, no, we got to go look at it how it from the inception, like the seed was poisoned from the very beginning. To do otherwise would be inefficient for this court because it would entail successive rounds of immunity determinations, and it would pose the risk of multiple interlocutory rounds of appellate review. So this is just so good. It's just gold. But the government is prepared to file its opening immunity brief at any time if you say so. So just like, let us tell you why our second draft indictment is much better. They also say Trump plans to file an additional motions to dismiss, I'm sure. The court has indicated that it will conduct its immunity determinations before resolving these other issues. So let's say Trump says, right, Trump wants to file a motion now to dismiss the case because Jack Smith is not a real boy. He's not even presidentially appointed or confirmed by the Senate. Totally illegitimate. So if Trump files that motion, right, she goes, well, I'm not even going to consider that until we talk about immunity. The government notes that it may promote judicial economy and resources for the court to schedule briefing of all other Rule 12 motions concurrent with the immunity litigation. That way, all motions will be fully briefed. The court can later determine when to take them in order. If the court sets a deadline for those other motions, the court requests the court set the same date for Trump's opening briefs for the government's open immunity brief, followed by parallel deadlines. Now, Trump's proposed schedule, as below, Jack Smith didn't even give us one because he's such a lazy, illegitimate prosecutor, also contemplates a separate deadline in motions. The government does not see a reason to delay immunity determinations and other reasons to separately address Trump's motions. And so that's what we have to say, Your Honor. So that's from Jack Smith. And this is so weak. So if Jack is not going to propose a hard deadline, well, Trump will take full license. They say, okay, sure. Well, here's what the defense proposes since Jack won't do it because he's so lazy. All right, how about September 30th? We'll have more disclosure disclosures. October 25th this year, we have motion concerning Jack Smith's. Oh, there it is. Here's the motion concerning the special counsel's improper appointment and use of non-appropriated funds that they are just getting ready to file. They're just like, oh, they're so excited for it. I'm so excited for it. I cannot wait because Jack Smith lost this one. This was the one that was filed in Judge Cannon's court, and Judge Cannon got rid of Jack Smith, said, you are illegal. Your appointment wasn't proper. And you took a bunch of money, $24 million, I think it wasn't counting, to prosecute Trump illegally. Where'd that money come from? Us. It was from a discretionary slush fund that the DOJ set up that Jack Smith stole. So then Trump says, all right, and then also, so we'll file this one on October 25th, and Jack Smith can respond by November 8th. Then Trump will reply by November 15th after the election. On the week of December 2nd, we have a hearing. So schedule the hearing when we'll argue about Jack Smith being deleted from this case. And then December 13th, then we can discuss immunity, right? And so Jack Smith is saying, no, actually, we don't want to do any of this. We'd rather go and have the immunity decision first. So in other words, accelerate, push all of this up in advance of the Jack Smith is illegal, not even a real boy motion. Trump supplement the statutory motion to dismiss based on Fisher. That's the 1512C issue about corruptly and impeding government documents that the Supreme Court backhanded the district court on. Defense counsel motion to compel immunity discovery is due. So Trump may separately identify which aspects of his pending motions should be resolved at this time. And just look, right? The rest of this is well into next year. So January 3rd, 2025, then Jack can respond to the motion to dismiss. At the end of January, then Trump can respond. Then at the end of January 2025, we have evident motions hearings. And then Trump's people are saying, we're probably going to have most of this dismissed at that time. So we don't even need to set a trial date. But in the spring into fall 2025, we'll start to schedule additional dates and additional times if necessary, because Jack Smith's illegal and Trump has immunity, as has been obvious from the very beginning. So all of this needs to go bye-bye. Here's the rationale for our schedule. Jack Smith, says Trump's team, has returned a superseding indictment that includes substantial changes to its prior allegations, right? They made a bunch of claims. As we saw, they deleted a ton of it out. Trump correspondingly requires time to review the new charging instrument as he determines what steps and procedures to take about his presidential immunity. So they're basically saying, no, this is like not a second draft, okay? It's a whole new indictment. So we should reset a lot of this. Like go back to zero, like day one. New game, start over. President Trump holds the right to challenge the new indictment, and the underlying grand jury process is a matter of law. An ordinary order is for those challenges to occur before substantive proceedings, as doing so will promote judicial economy. And we don't need to do a bunch of stuff if the case is going to be dismissed. Now here, Trump is considering several challenges to this, each of which should be resolved in his favor. And if it is in his favor, the case is going to be dismissed. Now, as a threshold matter at the very beginning, Trump is going to move to dismiss Jack Smith's improper appointment and his use of non-appropriated funds, aka stolen, illegal, not a real boy, and stole millions to prosecute Trump. Issues that a Supreme Court justice describes as serious questions that must be answered before the prosecution can proceed, says Justice Clarence Thomas, and which another district court called Eileen Cannon also found dispositive. These issues are critical. Jack Smith is not a real boy. In addition, while continuing to strongly maintain that many classes of conduct alleged in the indictment are immune, even in the new indictment, they're saying, even that's immune, Jack. Tweets are immune. Public statements about the election are immune. Communication with state officials about a federal election are immune. Allegations about alternate slates of electors. Trump may file a motion to dismiss all this. And we're also going to focus on Vice President Mike Pence, along with other key potential threshold motions. In Trump, the Supreme Court case where they decided on immunity, the Supreme Court held that President Trump is, quote, at least presumptively immune, right? We start with the presumption that you're immune. For all alleged efforts, the Supreme Court said, to pressure Pence to take acts in connections with his role. They said he's at least presumptively immune. Now, those allegations about Mike Pence are foundational to the superseding indictment. If Trump is immune from the Mike Pence stuff, he's immune from everything. Everything fails. If the court determines, as it should, that Jack Smith cannot rebut the presumption that Trump is immune for talking to his vice president about official business, binding law requires that the entire indictment be dismissed because the grand jury considered immunized evidence. So he's saying the Supreme Court has told you, Jack, and Jack, man, he's goofing this so bad. Did he not read that part of the Supreme Court opinion? It's at least presumptively immune, and he put it in the new indictment. So presidents cannot be indicted based on conduct for which they're immune from prosecution. And Jack Smith, right, if we go in this new indictment and we find that his inclusion of the conversation with Pence in there was immune, that means the grand jury heard immune stuff because they indicted him. That means everything else has to go. It's like a poison pill, right? It means that some of this got presented to the grand jury, so the entire indictment has to be dismissed. Now, Jack's inability to rebut the presumption as to Mike Pence is dispositive to this case, meaning it will settle the whole thing. He's not going to be able to show that it's illegal for Trump to talk to his vice president about official business. Could Trump talk to Mike Pence about his role at the time if Trump was not on the ballot? Of course he could have. Yeah, here's what I think. Someone else is running, and so their name is whatever. Ron DeSantis is running. Trump decided I'm not going to run again. Ron DeSantis is running. Democrats cheat their eyes out like they always do. Trump says, hey, Pence, I need to talk to you about what you're doing in that role because there was fraud and do these things. Obviously immune. It means that he also has a parallel interest. That's sure too. But this is not conflict of interest analysis. This is, can he talk to his vice president as a matter of law? Yeah, he can. That's the whole role of being a vice president. So Jack Smith, they say, will be unable to do this as a matter of law, rendering the remainder of the case moot. Trump's immune on that. Jack Smith included this little provision like an idiot, and now it's going to wreck his whole indictment, which is good for us. Now, he says, they write, from the Supreme Court, we therefore remand to Chutkan with appropriate input from the parties whether a prosecution involving Trump's alleged attempts to influence Pence's oversight of certification in his capacity as president of the Senate would pose any dangers of intrusion on the authority and the functions of the executive branch. So yeah, if the president cannot do that, if you criminalize the president, right, they lay it out for us here. Trump talking to the vice president, overseeing the proceeding, like all official, right? President with the vice president as his role as president of the Senate. That's the conversation that happens every day between the president and the vice president about their role in their execution of their duties. So further, President Trump may move to dismiss based on the Supreme Court's decision in Fisher, which is the 1512 C2 issue, which narrowed the ambit of obstruction charges. The Supreme Court directed that the court determine in the first instance whether this charge may proceed in light of the decision in Fisher. And so we got to resolve this too. Now, fully considering researching, says Trump's defense, and resolving each of these potential motions will take considerable time and resources. And so again, we're just basically talking scheduling here. So our proposed calendar accounts for this. It still moves the case forward quickly. It schedules the Jack Smith is not a real boy motion in October, and it would dismiss this case. We don't even need to talk about immunity. Okay. If Jack Smith is illegal, immunity is over. It's just the whole thing's gone. So such a schedule not only promotes judicial economy, but also vitally preserves the separation of powers. We do not want unnecessary litigation about Trump. The Supreme Court even explains the essence of immunity is its possessor's entitlement, the person who has the immunity. The power is they don't have to appear in court. That's what immunity is. It's like a force field. You're not immune if you're sitting there getting lectured by Judge Merchan. This, in large part, is part of the peculiar public opprobrium that attaches to criminal proceedings. Even if you're under investigation for a crime, there is stigma. It follows, therefore, that the court should take every reasonable step possible to resolve the case on legal grounds before permitting an invasive public inquiry into Trump's conduct. Trump's team says, we believe and we expect to demonstrate that this case must end as a matter of law. The facts here are important, but we don't need to unpack all of them. Should the courts determine otherwise, we have fashioned our proposed schedule to facilitate this, right? In other words, like Jack Smith is just illegally appointed by operation of law. So we don't need to go into immunity and Trump's conduct and all that stuff. As an initial matter, the Supreme Court broke new ground on the scope of immunity, which the special counsel previously maintained did not exist. Jack said there was no immunity, which was so dumb. Obviously, that was incorrect legally. They knew it, but they just had to say it. Now, as a result, with respect to unclassified and classified discovery, there are serious threshold questions about Brady and about the government's obligation to disclose information that might tend to exculpate or show someone's innocence. It cannot be assumed that any case file review by Jack at the outset of this case addressed their disclosure obligations based on intervening precedent. And therefore, there are outstanding disputes on this. Okay, they're saying that Trump was demanding a bunch of discovery and saying, well, I need this because it relates to immunity. And I think it relates to our claims of immunity. Jack Smith said, no, you don't even have immunity. What are you, nuts? You don't have immunity. So we're not going to give you the stuff that's related to your claims of immunity. And they're saying, well, obviously there's immunity. We were right. They were wrong. Supreme Court said there's immunity. So now we want that discovery that they said we couldn't have. So we have now proposed a deadline of September 30th for them to make supplemental productions about the immunity stuff that we already asked for. This will provide everyone sufficient time time, they can find the documents and give them to us. We've also set a control date on December 13th to file motions to compel. If they don't give us this immunity-related discovery, we're going to ask that they be compelled to do it. Such issues must be resolved before we can even prepare our motions. We're talking about immunity here. Now, to ensure that Trump has the full universe of all the potentially relevant documents, the court must permit him the opportunity to serve new immunity-focused discovery requests. This is so great. Jack Smith and his team, they must just be furious, okay? What's happening here is the defense is becoming the prosecutor, which is just so great. So, well, sounds like, Jack, you were hiding a bunch of stuff from us. We told you we needed immunity material, and you said you don't have immunity, but we do. And so how about we just start peppering you, and we're going to serve you new discovery requests, and we're going to seek relief from the court. If Jack Smith, who's not even a real boy, denies access to these documents, if he doesn't give it to us, we're coming right back to you, Judge. Hopefully, you can help us resolve these disputes, but the reality remains that immunity discovery must be requested, and we might even have to litigate over it because they didn't give it to us when we demanded it. This is going to take some time. So for similar reasons, if this case is not dismissed as it should be, this court must resolve Trump's motion now for an order regarding the scope of the prosecution team, which Judge Chutkan denied previously, which will affect the sources of documents that Jack Smith will be required to search for. Remember Jack Smith, he says that our prosecution team is like small. It's like me, Molly, Jay Bratt, handful of other dorks from the DOJ, TDS demented, freakazoids. That's it. Trump's people say, no, it's not. That's not the whole team. You have Homeland Security that was there on January 6th. You got FBI up the wazoo all over the place. You had the CIA who was involved, communicating. They wanted everybody. Secret Service was deleting their text messages, everything from everybody. You're all part of the team. And you were getting documents from everybody there, Jack. So they say, well, now we definitely need it because there are immunity concerns. So the need to resolve these issues is incompatible with the evidentiary submissions that Jack wants. Jack wants us to submit all of these motions and give you a briefing, Your Honor. How can we possibly give you a briefing when we don't even know what the scope of the evidence is? In the universe of Jack's case, we have to go learn about what they have that implicates these immunity issues before we can prepare our brief, obviously. So moreover, President Trump has had no opportunity to cross-examine Jack's witnesses or to call witnesses of his own, leaving the evidentiary record incomplete and incapable of supporting fact-based submissions. And so thus, immediately proceeding to fact-based submissions like Jack wants would violate the directive to do an objective analysis of the content, the form, and the context of each act, every single specific act, to determine if that act is official or unofficial. Now, proceeding to an evidentiary submission in this posture, just saying, well, you have enough. You know enough about immunity. We're just going to have a hearing. You don't need to research anything. They say that's ridiculous. That would violate the Sixth Amendment principle, including the right to present defense witnesses, to cross-examine the government witnesses, and more. Now, finally, Trump's defense wraps up, says, Jack Smith asserts that it should file an opening evidentiary brief, but it cites no authority or no rule to support that. Jack has drafted and filed its superseding indictment as it saw fit. It's now President Trump's right to challenge that indictment through appropriate motions and argument. Now, Jack Smith has no right to presumptively challenge submissions President Trump may make, to the extent that Jack suggests that informing Trump of its position on certain immunity issues in advance may be beneficial. Trump sees the rationale for that in principle. However, such information may be provided by the letter and should not take the form of affirmative briefings or filings. Okay. Now, Trump's proposed calendar addresses the threshold matters, and if the case is not dismissed as it should be, facilitates the exchange of this critical essential discovery over these next several months. Now, at the same time, the schedule promotes judicial economy, avoids undue burdens on the separation of powers, gives the unprecedented nature of this case, given it, this course is entirely reasonable. And so the court should adopt Trump's schedule and reject Jack Smith's proposal, which wasn't even much of a proposal. He just said, that's your discretion, Judge. You can just do whatever you want. But allow us to just submit some filings. As you can see, Trump's is a lot more thorough and aggressive. And I think, right, Jack Smith is in hot water. They're scrambling because, as you saw, what Trump is doing is he's reopening a bunch of the old stuff that's already been closed. Oh, well, part of the reason you denied us that is because you said that there was no immunity. Oh, but there is at least arguable amounts of immunity in those issues. So we got to reopen those and revisit those. And we cannot move this case forward, Your Honor, while there's still pending discovery out there. I mean, you wouldn't expect us to come and play a game when we don't have all of the materials we need in order to do that, would you? Of course, we'll see what Judge Chutkan says in response to this, but this was a joint motion making its way to Judge Chutkan's desk. I don't think she's going to be happy with this. She wanted to take this thing and put it right back on track so that we could have a trial maybe before the election. That's not going to happen now. And so we'll be here waiting for Judge Chutkan to issue a ruling, and we'll, of course, bring that update back. So thank you, my friends, for subscribing to our channel wherever you're watching this. We're going to have many more updates on this January 6th case, and I think there'll be spillovers into the New York case as this immunity decision takes hold. And we'll see you back here on the next one.